Your firm is representing a number of class action lawsuits, from forced sterilization to excessive force by the RCMP. Are you able to give us maybe a brief update on where these class actions are at?
I'll do my best. I mean, the nature of class actions is there's always discussions and developments that aren't yet public for a variety of reasons. You have to be able to have full and frank discussion. I don't want to sound like a politician, but full and frank discussion, not always in the public eye. And given the nature of these claims involving so many people and so often nationwide, it's important to recognize that. But generally speaking, the class actions in which we're involved fall into two categories. There are those that are certified, and there are those that are seeking certification. So really, what does that mean? It boils down to a question of whether a court has permitted claims that would normally be pursued individually to go ahead as a group or a class, and that's the whole concept.
Right.
So the law doesn't change just because you're pursuing a class action. So where are they right now? I'll give you sort of the headliners. The first one that most people are interested in, it's the oldest and probably the best developed of all the class actions that I'm involved with, particularly those that have a class that is exclusively Indigenous class members, and that's Indian Hospital's case. That's been going on for quite some time now. It covers a period of time between 1945 and 1981 in which Indigenous population members were compelled by circumstance, by law or otherwise, to attend a series of, depending who you speak to, 30 to 32 hospitals across the country. That was certified on consent some years ago. Discussions have been ongoing for all of those years since certification, and certainly COVID slowed down what had to be, for a variety of reasons, in-person discussions. We simply didn't make a lot of progress in terms of discussions, but we did make progress in terms of research. We have a variety of cases involving the RCMP, three in particular in which myself and my firm are involved. There's what is referred to as RCMP North, which involves a claim against Northern Aboriginal citizens who had interactions with the RCMP that were couched by, that were informed by racism and discrimination, which we say was not down to an individual officer or group of officers or time or place, but rather represents the systemic racism and discrimination which has been present in the RCMP, we say from its formation, and certainly despite many public pronouncements, continues to be an ongoing problem, an unresolved problem, and to a large extent unrecognized problem. So that one has also been certified, but it was not certified on consent. That was a contested certification, and it resulted in an appearance before the Federal Court of Appeal. Very recently, within the last few weeks, Federal Court of Appeal came down primarily on the side of certification, pruned, as the court said, some of the areas that we wanted to put before the court, but by and large, that certified class action is moving ahead as such. The government tried to decertify the class action, prevented from going ahead, was saying that we're doing everything we need to, and this should go ahead where necessary on the basis of individual claims. That was denied at the Court of Appeal. There's a companion case in which I'm also involved in southern Canada, which really covers the rest of the country outside of the territories. The territories was unique in the sense that it really has one policing service, other than bylaw services and other sort of regulatory bodies. But the South is identical in every other respect. And the only difference is that, yes, there are provincial and municipal enforcement agencies, but we're not dealing with them at this point. We're only dealing with the RCMP.
Right.
So in that case, we are not certified, but we're getting very close to certification because they are largely running in parallel. The Southern case was started later, so it's a little bit behind in the hopper. So those are the certified cases with which we are dealing. Those all involve discrimination. There is yet another one that is pending certification and is as close to certification, the certification hearing anyways, as any of the other cases, and that involves RCMP members. So these are not people that were interacting with the RCMP outside of the force, but rather inside of the force.
Okay.
And so discrimination, systemic discrimination and racism is not unique to people just out of uniform. The people in uniform were also subject to, we say, to the same sort of discrimination. And that one is approaching certification. there are others. I can go on if you want a complete list, but let me stop the monologue and turn it back to you for a moment, Darrell.
Well, given all of those cases that you had just mentioned, I feel I have to ask, why is it so important for you and your firm to be doing this kind of work?
When you think about the historical nature of these claims, it's just about time. I mean, these claims as individual claims rarely, if ever, go anywhere. There's a variety of reasons for that. There are strength in numbers, let's face it. The threshold for commencing a class action is such that not only does the group of people that you purport to represent as part of the class, not only do they need to have commonality amongst themselves, but it has to be both a productive use of court time, and there has to be an overall reason for going ahead as a group. And so class actions that my firm and others like ours pursue really do reflect societal wrongs, historical and ongoing wrongs that need to be addressed. And so we force institutions, churches, governments, cities, and provinces, for example, we force them to confront the problem. And we do it in a way that we are not, as a group, as a class, we are not beholden to the government. So, for example, in the Dirty Water case, it was decades of unresolved problems that took a class action to compel the government to do something about it. And it's the same thing with the RCMP. Residential schools was a bit different in the sense that that was a historical wrong that needed to be acknowledged. It was part of reconciliation, and compensation needed to be paid.
Right.
But without class actions, things don't happen. And we know that because we're representing people from back in the 30s in some cases, where nothing has happened and nothing would happen. And but for firms like ours and lawyers, I might say, like me, that hear about these cases and are approached, if we didn't take them on, nothing would change. Mm-hmm. So it's like the civil rights movement in the 60s. We simply provide the opportunity to get these cases dealt with, not voluntarily, not politically, but under mandate of the court. And that what makes our justice system so strong in this country. It allows disenfranchised or discriminated groups to come forward en masse.
Well, and Stephen, how difficult, or has it been difficult to find these class claimants and to find people for these classes?
Well, if by class claimants you mean the representative plaintiffs, it's not difficult at all in most cases.
Okay.
These cases are notorious. These cases involve a lot of people, and firms like ours are magnets for people like that, understandably, because they see us in the news, they see us on programs like this, they see the success that we've had in the past in getting matters resolved. And they tend to find us. So the representative plaintiffs who represent the classes that we want to bring before the courts and hold the government and institutions accountable, they tend to find us. And we take their ideas, and there are many potential class actions, but we take the ones that seem to have the most merit, not just economically and legally, but also socially. And, for example, when we're going ahead with Indian hospitals, these are hospitals that existed for decades. The class period is 1945 to 1981, just against the federal government. So almost 40 years in that instance. And we find that there are lots of people out there that are survivors, and their stories are finally told through the class action process. As far as if you're speaking about class claimants as members of the class, they find out about us once a matter is certified, and thereafter once it is settled or adjudicated in favor of the class. They find out about it by an institutionally funded mass media campaign. And it really does keep up with technology. So I saw when we settled the Labrador residential school action back in, 2017, that class action resulted in targeted Facebook posts, for example. So people don't always find out about it in a timely fashion, but most people do in most cases.
Well, you touched on my next question, and that was just me going to be asking you, how do you advertise for these, for them? How do you advertise for them? And you mentioned, so it's a bit of social media, I guess, a little bit?
Yeah, so again, we don't advertise for representative plaintiffs, but by class members,
right, which
could be characterized as class claimants once the matter has been settled or adjudicated in favor of the class. It really is just mass media. So we use social media. People like me come on programs like yours and talk about it. It's really hard to escape the information, even if you aren't looking for it. If you're looking for it, then it's easy to find. The other way, frankly, is we encourage people to contact us. So, for example, I don't know the exact number, but it's about 4,000 or 5,000 people in the hospital's case are in our database. They don't need to look for the information. We push it out to them, and as settlements or major milestones are met, they get information. So it's extremely important for a number of reasons that potential class members, they don't need to know whether they're class members, they just need to think they might be. Contact lawyers like me, get yourself in the database, because we also use that data anonymously to give to experts to help us formulate what a settlement might look like. If we don't know that something has happened to a number of people, that tends not to be included in the settlement. And so the importance of contacting the class action lawyers involved is both selfish in the sense that you get put onto an information stream. You're part of the information highway then. But second of all, in an aggregated form, aggregated, not aggravated, form, we get to use the information anonymously for statistical purposes, and that's what settlements are based on. They're based on stats.
So while we're on the subject then, the purpose of our show today is to update our audience with how they can participate if they believe a class action applies to them. So what is your advice then in this case?
Call me. If it's a case in which we're involved, or if it's a case you think has some merit, just call me. I mean, you can call our toll-free number. I sound like an advertisement now. You asked me about advertising. Here it is, I suppose. 1-800-994-7477. You can contact info at Cooper Regel. Regel's with two E's, not an A. COOPERREGEL.ca. And just ask us questions or give us information. We have questionnaires available on each of the claims in which we're involved. Where settlements are negotiated or adjudicated, then we have claim forms that are also available in the same place. Okay, perfect. We'll get that info out there. And when it comes to working on a class action, or maybe launching a class action lawsuit, what are the resources like, and what are the resources like for involving them? How many lawyers are working on them? Can you give us a bit of maybe insight into what goes into that? Yeah, sure. I mean, I've always said to junior lawyers to remember that law firms are kind of like black boxes. You know, people come in, something happens, rattles inside, and something comes out. And so it's important to sort of look in the box or lift the curtain. There really isn't any magic about it in the sense that we assign a number of lawyers and other staff that are necessary, and that ebbs and flows depending on what type of case it is and where you are in the case. Okay. So as we're collecting information to convince a court to allow a class action to proceed, because unlike other actions, you need the court's permission to even get started. So you have what's called a putative or proposed class with a putative and proposed group of issues and people. So we assign a number of people, lawyers, paralegals, and experts as is necessary. Historical claims always involve archival searches and experts. Every one of our class actions that go back more than 10 years, for example, require archival research. A distinction, for example, in the privacy breach in the Northwest Territories, which we think affected 60,000 people, but not uniquely Indigenous in that case. Right. We're not looking at historians. We're looking at technical experts trying to help us understand how such information is misused on the dark web or otherwise. Right. And Stephen, in the case of historic abuse, like the Indian hospitals, how cooperative has the government been in providing documents? Well, the court compelled to. I mean, the rules of court compel a party, and it doesn't matter if it's a federal court or the guy next door or the girl next door. They're compelled to give us whatever they reasonably can access. So it's give and take. I mean, we will, and our experts in particular will say, we need information on this. What do you got? Right. Okay. The problem really is less with the defendant, in this case, the federal court, and it's more with third parties, because the reality of Indian hospitals, as we've discovered, is that the archives that do exist are deficient because of normal destruction policies and loss and fires and just misfiling and mishandling. But also the documents are everywhere. I mean, I was shocked to find out that the city of Edmonton archives apparently have a huge amount of information about one of the largest, if not the largest, of the Indian hospitals, as they were called, which is the Camsell Hospital in Edmonton. And for some reason, some of the archival material was transferred to the city. That came as a surprise to us, so we have to approach them. The Northwest Territories, the Prince of Wales Heritage Museum, for example, which is the official archive of the GNWT, has some. So finding documents is not just about the cooperation of the defendant, in this case the federal government, but of figuring out where things are and often seeking court orders along the way to ensure that the material is available. What happens with third parties is that they'll often, and quite reasonably and justifiably, say, we can't give you this information. We'd love to, we'll cooperate, but you need a court order. So then we have to go to court, often with the cooperation and collaboration of the defendant, to get that information. And sometimes the most important information is held personally in people's files. Photos of people. Anne Hardy, who's our representative plaintiff in the hospital's case, for example, has a very compelling picture of her while she was a patient at the Camsell Hospital. It puts her there, one of the things, and then they tell us things as well. So we discovered through some of our putative class members, in that case class members, about a radio broadcast that was done from Camsell and internal news sources. So the documents are found everywhere on these types of cases, and that's unfortunate. It makes it really difficult to get a complete understanding of what happened, and it makes it difficult to prove that somebody was there if that's necessary. Well,
Stephen, there's certainly plenty to think about and a lot of information there, but we certainly appreciate you coming on and sort of breaking that down for us. And I know our audience is going to be that much more knowledgeable should they maybe think they're part of a class action. So again, thank you so much for coming on, and this is such an important discussion. So we really appreciate your time.
Information is power, Darrell. Thank you so much for your interest.